They waited until we were at the ceremony. 12 homes, 12 American flags, all removed from their front porch brackets, while we stood at Fort Bragg's memorial grounds, saluting the men and women who never came home. We returned from honoring the dead to find our flagpoles empty, our brackets scraped clean, and a violation notice taped to each door with the same typed sentence. Display of unapproved exterior decorations is prohibited under Section 7.14 of the Briarwood Estates Community Guidelines. Flags are not decorations. And the people who took them were about to learn that lesson in a way that would cost them everything they had. My name is Ray Delgado, 39 years old, Master Sergeant, United States Army. 18 years in with 2 combat tours and a knee that predicts rain better than any weather app. I live in Briarwood Estates, a subdivision about 20 minutes outside Fayetteville, North Carolina, close enough to Fort Bragg that you can hear artillery exercises on quiet mornings. My wife Maria teaches 4th grade at a school where half the students have a parent deployed at any given time. We moved to Briarwood in 2020 because the houses were new, the schools were good, and the neighborhood felt like exactly what we needed after my second tour. What nobody mentioned during the walkthrough was that the HOA was run like a small authoritarian country with a 63-page rulebook and a president who believed she was its Supreme Court. Briarwood Estates had 188 homes. Of those, roughly 40 were owned by military families stationed at Bragg. We weren't a majority, but we were a presence. You could tell which houses were ours without checking. Challenge coins on windowsills, unit stickers on truck bumpers. That particular tidiness that comes from years of passing barracks inspections. We kept our lawns sharp. We followed the rules. We were, by any reasonable measure, model homeowners. The HOA president was a woman named Vivian Kessler, 61 years old, retired pharmaceutical sales manager, lived in the largest house on the cul-de-sac at the end of Briarwood Drive. Vivian had been president for 9 years. She ran the board with 3 allies. Her neighbor, Don Pratchett, who was the treasurer, a woman named Laura Sims, who handled architectural review, and Vivian's own son Bradley, who served as secretary despite living in Charlotte and attending maybe 2 meetings a year via speakerphone. Together they controlled every vote, every budget line, every enforcement action. Elections happened annually, but Vivian always won because most people didn't bother showing up, and the ones who did were generally there to complain about parkin', not stage a revolution. I'd had minor friction with Vivian before. She once sent me a violation for leaving my garage door open for more than 30 minutes while I was unloading groceries. Another time she cited my wife's classroom project, a painted rock garden along our walkway that the neighborhood kids loved, as an unapproved landscape modification. We painted over the rocks. It wasn't worth the fight. That's what Vivian counted on. Everyone deciding it wasn't worth the fight. The flag issue started in October 2023. Vivian distributed a memo to all homeowners announcing updates to the exterior display policy. The relevant section read, effective November 1st, all exterior displays, including but not limited to flags, banners, seasonal decorations, and signage, must receive prior written approval from the Architectural Review Committee. Displays not conforming to the approved aesthetic standards of Briarwood Estates will be subject to removal and fine. I read it twice. Then I read it a third time because I thought I was misunderstanding something. She was requiring approval to fly the American flag. I called my neighbor Cal Turner, a staff sergeant in the 82nd Airborne who lived 4 houses down. Cal had a flagpole cemented into his front yard that he'd installed the week he moved in. Flew the American flag and the 82nd Airborne Division flag underneath it. "You see this memo?" I asked. He laughed. "She can't be serious. She's always serious." Cal and I knocked on doors that weekend. Found 10 other military homeowners who flew flags regularly. 12 of us total. We agreed to keep flying our flags and ignore the memo. It wasn't civil disobedience. It was common sense. You don't ask permission to fly the flag of the country you serve. November 1st came and went. Nothing happened. November 5th, Vivian sent individual violation notices to all 12 of us. Unapproved exterior display. $50 fine. Remove within 7 days, or face escalating penalties. I called Vivian directly. "Vivian, these are American flags. We're military families. You can't fine us for displaying the flag." Her voice was pleasant in the way a closed door is pleasant. "Ray, the policy applies equally to everyone. If I allow flags without approval, next week someone hangs a Confederate flag or a marijuana leaf banner and claims the same exemption. Standards exist for a reason. This is the American flag. The flag I deploy under, and I respect your service deeply. But the CC&Rs don't have a military exemption. If you'd like to submit a flag display application to the Architectural Review Committee, Laura can process it within 15 business days. 15 business days. Veterans Day was November 11th, 6 days away. She knew that. I paid the fine because I didn't have time to fight. All 12 of us paid. $50 each, $600 total flowing into the HOA account, and we kept our flags up because Veterans Day was coming, and taking down the American flag the week before, it felt like something none of us could stomach. November 11th, 2023, Veterans Day. Fort Bragg holds a ceremony every year at the memorial grounds. It's not optional for most of us. It's formation, dress, uniform. The kind of event where you stand at attention while they read names that include people you trained with, people you ate MREs with in the dark, people whose kids play with your kids. You don't skip it. All 12 of us left for the ceremony that morning between 0700 and 0800. Some drove alone. Some carpooled. Maria stayed home because she had the day off from school. She was baking a pie for the neighborhood potluck that evening. She called me at 1100. "Ray, something's happening outside. There's a man on a ladder at the Turner's house taking down their flag." "What? He's got a truck with a ladder? He's going house to house?" "He just finished the Petersons. He's heading to the Marshalls now. Maria, go outside and stop him." I tried. He showed me a work order signed by Vivian. Says he's authorized to remove unapproved displays. He told me to step back or he'd call the police for interfering with contracted services. I left the ceremony. Told my commanding officer there was an emergency at home. Drove 22 minutes at speeds I won't admit to. When I pulled onto Briarwood Drive, the truck was gone. So were all 12 flags. I stood in my front yard staring at the empty bracket above my door. The flag that had been there was the one I'd carried in my rucksack through 2 deployments. It had sand from Afghanistan ground into the fabric. Maria had washed it 100 times, and the sand never fully came out. That flag was irreplaceable. not because of what it cost, but because of where it had been. I walked to Cal's house. He was already home, standing in his yard looking at his empty flagpole with an expression I recognized from downrange. The quiet before someone makes a decision they can't take back. She waited until we were at the ceremony, he said. Yeah, she knew we'd all be gone. Yeah, Cal looked at me. What do? We sued the HOA. Within 48 hours, all 12 homeowners met at my dining room table. Maria made coffee and set out cookies that nobody touched. The energy in the room was deployment briefing serious. Everyone in that room had trained for high-stakes situations. Nobody was panicking, but nobody was calm either. I'd spent the previous day researching and found something that made my blood pressure spike. The Freedom to Display the American Flag Act of 2005, federal law. Public Law 109 to 243. It states that a condominium association, cooperative association, or residential real estate management association may not adopt or enforce any policy or enter into any agreement that would restrict or prevent a member of the association from displaying the U.S. flag in accordance with Federal Flag Code. I read it out loud to the room. The silence afterward was heavy. Cal spoke first. So what she did is literally a federal violation? Not just a violation, said Angela Park, a captain in military intelligence who lived on the next street. She didn't just enforce a policy. She physically removed federal flags from private property while the owners were at a military ceremony. That's not enforcement. That's confiscation. And depending on how the court reads it, it's potentially theft. But here's where it got complicated. I called 3 lawyers that week. The first 2 were local attorneys who handled HOA disputes. Both said the same thing. The Freedom to Display Act has limited enforcement mechanisms. It's more of a declaration of principle than a law with teeth. There's no specified penalty. You can sue for injunctive relief, meaning a court order to stop the policy, but damages are hard to prove. One flag costs, what, $30? My flag doesn't cost $30, I said to the second attorney. It's irreplaceable. I understand that emotionally, he replied, but courts deal in market value. Sentimental value is almost impossible to recover. The third lawyer was different. Her name was Patricia Okafor. She was 45, former Army JAG, now in private practice in Raleigh, specializing in military civil rights cases. She de-sued an HOA in Virginia 2 years earlier for restricting a Gold Star family's memorial display and won a 6-figure settlement. She charged $300 an hour, and she was worth every penny. Patricia listened to our story for 30 minutes without interrupting. When I finished, she asked one question. Did Vivian Kessler know you were all at a military ceremony when she sent the contractor? I believe so. The ceremony is public knowledge. It's on the base calendar, and the local news covers it. Can you prove she knew? Maria said. Vivian asked her last week what time the ceremony started. Said she wanted to attend. Patricia leaned back in her chair. She didn't attend the ceremony. She used the information to time the removal. That's premeditation. That changes everything. She explained the strategy. The Freedom to Display Act alone was a weak sword, but paired with the Service Members Civil Relief Act, the Fair Housing Act's protections against discrimination. Based on military status which North Carolina had adopted in 2021, and state law claims for trespass and conversion of property, we had a multi-layered case. But I want to manage your expectations, she said. This isn't a slam dunk. Vivian will argue the policy was content neutral, meaning it applied to all flags and displays, not just military ones. She'll say she was enforcing rules that existed before you moved in. She'll say the contractor was authorized under the CC and RS. And some of those arguments have legal merit. Even with the federal flag law. The federal flag law has never been tested in the Fourth Circuit for a case exactly like this. We'd be making new law? That's exciting for lawyers and terrifying for clients. We retained Patricia the next day. All 12 families split the retainer, $2,000 each. $24,000 total. Most of us put it on credit cards. Some borrowed from family. Angela Parks sold a motorcycle. Nobody hesitated. Patricia filed the complaint in federal court on November 28, 2023. Delgado ETL versus Briarwood Estates HOA. 12 plaintiffs, the HOA as primary defendant. Vivian Kessler individually as secondary defendant. Claims under the Freedom to Display Act, SCRA, Fair Housing Act, and North Carolina state law for trespass, conversion, and intentional infliction of emotional distress. The local news picked it up immediately. Fayetteville Observer headline: Military families sue HOA for removing American flags on Veterans Day. The story went regional within 48 hours and national within a week. Fox News called, CNN called, Stars and Stripes ran a feature. Patricia advised us to decline all interviews until after the initial hearing. Let the complaints speak, she said. The facts are more powerful than sound bites. Vivian hired a defense attorney named Glenn Harwick from a Raleigh firm that specialized in HOA defense. Harwick was experienced and smart. His first move was a motion to dismiss, arguing that the Freedom to Display Act did provide a private right of action, meaning individual homeowners couldn't sue under it directly. Only the government could enforce it. Patricia had anticipated this. She filed a response citing 3 district court decisions that recognized implied private rights of action under similar federal statutes. She also argued that even if the Flag Act claim failed, the remaining claims were independently sufficient. The motion to dismiss hearing was in January 2024. Judge Elaine Woodruff, a Clinton appointee with 22 years on the bench and a reputation for meticulous analysis. She took the motion under advisement and ruled 2 weeks later. The Freedom to Display Act claims survived, barely. She wrote that the question of private enforcement was unsettled, but that the plaintiffs had stated a plausible claim. The other claims survived easily. We were going to trial. But discovery revealed something none of us expected. Patricia subpoenaed the HOA's financial records, meeting minutes, and all communications between board members. What came back was 800 pages of documents that told a story more complicated than good versus evil. The HOA's finances were actually well managed. Vivian had negotiated below-market contracts for landscaping and snow removal. She'd built the reserve fund from $12,000 to $91,000 in 9 years. Property values in Briarwood had increased 28% during her tenure, outpacing comparable neighborhoods by 11 points. She was, by the numbers, an effective administrator. But buried in the meeting minutes was something else. 3 years of escalating complaints from non-military homeowners about what they called preferential treatment of military families. One resident had written, "The soldiers think they can do whatever they want because they serve. The rules apply to everyone." Another complained that military families got away with things like parking tactical vehicles in driveways and having frequent visitors, staying in guest rooms beyond the approved limit. Vivian had responded to these complaints by tightening enforcement across the board. The flag policy wasn't created to target military families specifically. It was created because Vivian was trying to maintain the appearance of equal treatment while managing a neighborhood where 40 families had fundamentally different lifestyles than the other 148. This didn't make what she did right, but it made it more complicated than 12 heroes versus one villain. Patricia showed me the documents. "This hurts us on the discrimination claim," she said. If she can prove the policy was content neutral and applied to all flags including sports banners and political signs, the Fair Housing Act claim gets weaker. What about the timing? She did it on Veterans Day while we were at the ceremony. That's our strongest argument. The policy might be neutral, but the enforcement was targeted. She chose the one day she knew all 12 military homeowners would be away simultaneously. That's circumstantial evidence of discriminatory intent. Circumstantial isn't the same as definitive, I said. No, it isn't. Patricia closed the folder. "Garrett, I need to ask you something. Would you consider settling?" The question hit me like a bucket of cold water. For what? Harwick called me yesterday. Vivian's offering to rescind the flag policy permanently, return all 12 flags, or replace them at market value, waive all outstanding fines, and issue a written apology to be published in the HOA newsletter. No monetary damages. I thought about my deployment flag with Afghanistan sand in the weave. Market value was maybe $40. Real value was immeasurable. No money. No money. She says she's not wealthy. The HOA's reserve fund would be wiped out by a significant judgment. Every homeowner's dues would increase to rebuild it. So if we win big, the other 176 homeowners suffer. Patricia nodded, including the military families who aren't part of this lawsuit. I brought the offer to the group that night. The discussion lasted 3 hours. It was the first time we disagreed about anything. Cal wanted to reject it outright. She stole from us on Veterans Day. She doesn't get to apologize her way out of this. Angela Pock was more measured. If we bankrupt the HOA, we hurt ourselves. Our property values drop. Our dues skyrocket. We win the battle and lose the neighborhood. A staff sergeant named Jerome Washington, who'd been quiet most of the evening, said something that stopped the room. My grandmother flew a flag outside her house in Alabama in 1968. Someone tore it down because they said, "Black families did UNT have the right." She put it back up the next morning. And the morning after that, she never sued anyone. She just kept putting the flag back up. Sometimes winning isn't about punishment. It's about the flag being there tomorrow. The room went quiet. We voted 7-5 in favor of a modified settlement. We'd accept the policy change, the apology, and the flag returns, but we wanted 2 additional conditions. First, the HOA would implement a mandatory annual training on federal housing laws, including the Freedom to Display Act, the Fair Housing Act, and the SCRA. Second, Vivian would step down as president. Patricia presented the counteroffer. Harwick called back within 24 hours. Vivian accepted the training requirement. She refused to resign. Patricia called me. She says the presidency is elected and she won't be forced out by litigation. Legally, she has a point. We can't compel her removal through a settlement. That's a governance issue for the membership. We debated for another 2 days. Finally, we accepted without the resignation demand. But Angela Park had an idea. If she won't step down voluntarily, we run against her. We have 40 military families in this neighborhood. We've never organized for an HOA election. What if we did? The settlement was finalized in March 2024. Vivian signed the agreement in Harwick's office. The apology was published in the April newsletter. It was 3 paragraphs long and read like a legal document, technically apologetic without admitting wrongdoing. But it was public, permanent, and it acknowledged that the flag removals were wrong. The flags went back up on a Saturday morning. All 12 of us did it together. Kel put his 82nd Airborne flag back on his pole and saluted it. Maria hung our deployment flag on the bracket above the door and ran her fingers along the fabric, where the sand still lived in the threads. Jerome Washington's wife tied a yellow ribbon around their flagpole that she'd been keeping in a drawer since his last deployment. Nobody cheered. It wasn't that kind of moment. It was quieter than that. More like exhaling after holding your breath for months. The HOA election was in May. Angela Park ran for president. She campaigned door to door for 3 weeks, not just military homes, but every home. She talked about transparency, about publishing meeting minutes online, about creating a resident advisory committee. She talked about Vivian's genuine accomplishments, the reserve fund, the property values, and she promised to continue them. She didn't run against Vivian. She ran for something better. Vivian campaigned too. She knocked on her own doors, reminded people of the numbers, the 28% property value increase, the low dues. She had supporters. Real ones, not sycophants. People who valued what she'd built and worried that change meant chaos. Election night, the community center was standing room only. 112 homeowners voted, the highest turnout in Briarwood history. Angela won, 91 to 61. But 61 people voted for Vivian. That's not a landslide. That's a divided community choosing a new direction by a margin that demands humility from the winner. Angela's first act was appointing a transition committee that included 2 of Vivian's supporters. Her second act was commissioning a permanent flag display policy that complied with federal law while addressing the aesthetic concerns that non-military homeowners had raised. The compromise allowed any U.S. flag, military branch flag, or POW MIA flag without approval. All other flags required a simple notification, not approval, to the board. No flag could be prohibited based on content unless it violated obscenity laws. It wasn't perfect. Some military families wanted 0 restrictions. Some non-military families thought any flag policy was too permissive. But it worked because it was built by the community, not imposed by one person. Vivian Kessler still lives in Briarwood. She attends meetings. She votes. She submitted a formal comment on the new landscaping contract last month that was actually quite insightful. She and Angela Park are not friends, but they're civil. Angela told me recently that Vivian cornered her after a meeting and said, "You're doing a decent job. Don't let it go to your head." I think about the settlement sometimes. Whether we should have pushed harder. Whether we left money on the table that would have sent a stronger message. Cal still thinks we were too soft. Jerome thinks we got it exactly right. I land somewhere in the middle, which is probably where the truth usually lives. What I know for certain is this. The Freedom to Display the American Flag Act exists because Congress understood something fundamental. The flag isn't a decoration. It's not an aesthetic choice. It's not subject to community palette guidelines or architectural review committees. It is the symbol of a promise that this country will protect the rights of the people who protect it. When Vivian Kessler sent a contractor to remove 12 flags from 12 homes on Veterans Day, she didn't just violate a federal statute. She broke that promise. And while the law's teeth were duller than I wished, the community's response was sharper than any judgment. 12 flags came down on November 11. 12 flags went back up in March, and now 188 homes know that those flags aren't going anywhere. If you've dealt with an HOA restricting your right to display the American flag or targeting military families with selective enforcement, I want to hear about it. Drop your story in the comments. Not for entertainment, for the record, because every story documented is another reason to strengthen these protections. And if you're on an HOA board somewhere, before you draft that policy, before you send that contractor, before you touch a single flag, ask yourself one question. Do you really want to explain to a federal judge why you removed the American flag from a soldier's home on Veterans Day? Subscribe if you believe homeowners should fight back. Next week, an HOA foreclosed on an 83-year-old widow over a $300 fine. Her grandson was a prosecutor. They didn't check. See you then. Keep your receipts. Fly your flags. Sue the HOA YouTube video description. On Veterans Day 2023. While 12 active duty military families attended the memorial ceremony at Fort Bragg, their HOA sent a contractor to remove every American flag from their homes. The violation notices called our flags unapproved exterior decorations. What the HOA president did know is that the Freedom to Display the American Flag Act of 2005 makes her actions a federal violation. This is the story of how 12 military families fought back, what we won, what we lost, and why the real victory had nothing to do with money. If your HOA has ever restricted your right to fly the flag, this one's for you.